Okay. All right, good afternoon, everyone. It's my pleasure to welcome you to the 2025 Sumner Canary Lecture here at Case Western Reserve University School of Law. Before I introduce our distinguished guests, I'd like to share a little bit of background on this really exceptional lecture series. The Sumner Canary Memorial Lecture is perhaps the law school's premier endowed lectureship. It's tough to say that in this room with other faculty members who have other endowed lectureships, but it's really, if you think of the folks that we've had here over the years, it really is a pretty exceptional series. It was established to honor the memory of the late Judge Sumner Canary, a judge on the Ohio Court of Appeals for the 8th District, U.S. Attorney for Northern District of Ohio, and a partner at Canary and Walsh, and then later Arter and Hadden. The lecture was made possible by the generosity of Judge Canary's widow, Nancy Canary, and as I said, it has a really distinguished history. We've been honored to have had hosted Justices Sandra Day O'Connor, Warren Burger, Justice Scalia, Justice Kavanaugh, Justice Gorsuch, and I think most recently Justice Amy Coney Barrett, shortly before she came to the bench. Our moderator is a dear friend of the law schools, one of the nation's leading scholars in administrative law and environmental law, Professor Jonathan H. Adler. Professor Adler currently serves as the Cabell Research Professor and Tazewell Taylor Professor of Law at William & Mary Law School, and prior to joining William & Mary, Professor Adler served as the inaugural Johann Verhey Memorial Professor of Law and founding director of the Burke Center for Environmental Law here at Case Western Reserve University. Our speaker today is Judge Patrick Bumatay of the Ninth Circuit Court of Appeals. He's a graduate of Yale University and Harvard Law School, and he's built really an impressive career at the intersection of public service, appellate advocacy, and justice at the highest levels of our legal system. Before his appointment to the bench in 2019, he served as a federal prosecutor in the U.S. Attorney's Office for the Southern District of California, my home U.S. Attorney's Office, if you can say that, where he handled some of the most complex and sensitive cases ranging from organized crime to drug trafficking to fraud. He also served in roles at the U.S. Department of Justice's Office of Legal Policy and at the Office of the Associate Attorney General. His career represents not only professional excellence, but also a powerful example of dedication to public service. And he has, of course, remained deeply engaged in the scholarly and practical questions that shape our legal system, as evidenced by his topic tonight, publishing and speaking on constitutional interpretation, statutory construction, and the roles of judges in our democracy. We are truly privileged to have him with us here today to share his perspectives on judicial restraint in modern originalism as part of the Canary Lecture Series, which, of course, is dedicated to fostering dialogue on pressing issues of law, policy, and justice. So please join me in giving a warm welcome to Judge Patrick J. Bumatay.
Thank you so much, Dean. Thank you for that introduction, and I thank Case Western Reserve for inviting me to give this lecture. It's such an honor to be speaking in front of you. You know, the Dean just listed the legal luminaries that have given this talk, so I'm quite humbled to be giving this presentation, and I hope that I can add something to the debate that this lecture series has sparked. Before I begin my formal remarks, I wanted to give you a little bit of a background about myself, because I think it explains who I am as a judge and as a person. My grandfather came to the United States from the Philippines in the 1920s. He crossed the Pacific on a steamship with nothing more than a luggage in his hand. After he landed in San Francisco, he worked as a farm laborer, picking fruits and vegetables across the fields of California. He was able to scrape by and then put himself through college and then even earned a PhD. He then returned to the Philippines to start his own family. My parents immigrated to the United States in the 1970s. They were lucky enough to have their medical educations. So with that education, with work ethic, with faith and family, they built a beautiful life for my sister and me. And as the Dean mentioned, I've dedicated my career to public service. I spent most of my professional life as a prosecutor in San Diego, targeting the cartels in South America and Mexico, trying to ship ton quantities of narcotics into the country. I've also had great opportunities in Washington, D.C. As the Dean mentioned, I worked for all three leadership offices of the main justice. First as the Associate Attorney General, it was part of the Associate Attorney General's office, which is number 3 at Department of Justice, then the Deputy Attorney General, who's the number 2 at the department, and then for the Attorney General, who's of course the number 1 at the department. For baseball fans, I like to say that I hit for the cycle at DOJ. And since 2019, I've served as a judge on the U.S. Court of Appeals for the Ninth Circuit, a job that I never could have dreamed of. So as you can see, I like to say that the American dream has struck my family at least 3 times. First with my grandfather, then with my parents, and now with me. I think that shows that the American dream, that the United States is an exceptional nation, and that our legal institutions are surely a part of that reason. So I start off with the premise that our Constitution is one of the greatest legal documents in history, and our legal system is the best in the world. And a close corollary to that belief is that originalism is the judicial philosophy that gives the greatest fidelity to the words of our Constitution. Simply, it requires that we interpret the Constitution according to its original public meaning. Thus, we read the Constitution based on what it meant when it was ratified. I come to this conclusion from a Lockean perspective, that the people are sovereign and government authority derives solely from what the people delegate to it through our Constitution. To respect this, judges must follow the words of the Constitution as the people understood them until the people decide to change it. Failing to follow the Constitution's original public meaning then alters the people's consent and places the judge's will above the people's. Today, I'd like to talk about the meaning of judicial restraint in this world of originalism. In particular, how are originalist judges to view judicial restraint when we often face non-originalist precedent and non-originalist legal arguments? The legend goes that Justice Scalia once referred to his colleague Justice Thomas as a bloodthirsty originalist. In contrast, Justice Scalia famously dubbed himself as a faint-hearted originalist. I'm quite confident that Justice Scalia didn't use these terms because he thought his friend Justice Thomas was a vampire. Instead, I presume that Justice Scalia called Justice Thomas bloodthirsty because of his absolute adherence to the original public meaning of the Constitution, come hell or high water. I'm less certain as to whether Justice Scalia meant this term as a compliment or insult. But I must confess, I've outed myself as a bloodthirsty originalist since joining the bench. After all, is there any higher praise than being told you're ruthless in your search for the right answer about the law? So while the official title of this talk is Perspectives on Judicial Restraint in Modern Originalism, I like to joke that the real title should be Confessions of a Bloodthirsty Originalist. So first, some background. The concept of judicial restraint rose to prominence as a guiding judicial directive in reaction to the Warren Court's judicial excesses. Many saw decisions like Griswold, Gideon, and Matt versus Ohio as examples of the judiciary acting beyond its lawful power in our constitutional system. Opponents of this overreach saw the mantra of judicial restraint as a powerful bulwark against this activism. It sought to narrow judicial rulings, shun judicial innovations, and deferred to democratic majorities. In its earliest iteration, originalism was seen as a tool of a promotion for judicial restraint. Early originalists like Robert Bork justified the method as a way to ensure that judges wouldn't inject personal policy preferences into the judicial process. Instead, they would ground their decisions in the text and allow the democratic process to play out. Thus, early originalism was more about judicial restraint, not necessarily about a faithful understanding as to what the law is. To be sure, originalism is a constraining principle. In fact, I think, and I would argue that it limits judges' discretions the most out of any judicial philosophy. Because we appeal only to the Constitution's original meaning, amorphous concepts such as constitutional progressivism or living constitutionalism are replaced by a more objective inquiry into textual meaning. Originalism requires judges to put all our cards on the table, explain our methodology, and give the objective evidence supporting our view of the law. At the very least, it provides an objective ground to criticize our decisions. That's not the case when judges rely on subjective inquiries, like deciding whether an interest is compelling enough. So originalism does support judicial restraint. But originalism and judicial restraint don't always go hand in hand. Because judicial restraint focuses on prudential or political considerations, like a presumption for democratic outcomes, it does not ensure that we are following the original meaning of the Constitution or the plain meaning of a statute. So judicial restraint conflicts with originalism when it prevents courts from reaching results dictated by the Constitution's text and historical understanding. For example, I voted to strike down California's ban on large capacity firearm magazines, even though it was enacted by large majorities of Californians in a referendum. That's because California's law violates the original meaning of the Second Amendment's right to keep and bear arms. I've questioned whether Oregon can deny a therapist a license because he engages in religious counseling as part of his therapy as violating the original meaning of the First Amendment right. I've also written that many cities, a system of parking enforcement is unconstitutional. So you know when parking officials chalk your car tires to find out if you exceeded the parking limit? Well, that violates the original understanding of the Fourth Amendment as a suspicionless search. Those who advocate judicial restraint as the highest ideal would likely balk at these decisions as counter-majoritarian or anti-democratic or unsupported by established precedent. But when adhering to the Constitution, that does not matter. My oath to the Constitution trumps all else. Don't get me wrong, as I've said, judicial restraint isn't purposeless. It is wise to remember that judges are unelected and that the Constitution relegates us to the weakest branch. But those aren't the only considerations. Our highest duty is always to follow the Constitution. So fidelity to the law is paramount, and that means we must disregard judicial restraint whenever it gets in the way of following what the law is. So I want to talk about the interplay of judicial restraint and originalism in three areas. I will posit how I think bloodthirsty originalists should think about these issues. First, I'll briefly talk about lower court stare decisis. Particularly, I want to examine when federal appellate judges should vote to reverse non-originalist circuit precedent. And as a spoiler alert, the answer is always. Second, I will discuss how judges should determine what is binding in non-originalist precedent. In other words, what is a holding and what is dicta? After all, how broadly or narrowly you read precedent is crucial to determining how much leeway you have to base a ruling on originalist principles. And so the salient question really is, once you determine the scope of non-originalist precedent, how far must lower court judges go to extend that precedent? And another spoiler, not much. Third, I will focus on party presentation. How much discretion do lower court judges have to decide a case on grounds not precisely articulated by the parties in the case? Can judges undertake originalist research when it's not in the record? Once again, how strongly we view the party presentation principle will dictate how easily judges may reach originalist analysis and outcomes. So it won't surprise you to hear that I think party representation is only a weak presumption. Finally, I'll end with a bloodthirsty originalist roadmap. I'll draw together all these concepts and show how I think a lower court originalist judge should grapple with constitutional questions. Okay, so let's dive into the merits. First, stare decisis. To begin with, vertical stare decisis is simple for lower court judges. We always have a duty to follow Supreme Court precedent. We'll talk later about what is precedential in those decisions and how we must apply it, but no serious originalist would question our duty to follow the Supreme Court. As Justice Gorsuch recently said, lower court judges may sometimes disagree with the Supreme Court's decisions, but we are never free to defy them. That said, horizontal stare decisis presents a more interesting question. By horizontal stare decisis, I mean, when should lower court judges overturn circuit court precedent? In the Ninth Circuit, we have a rule that no three-judge panel may overrule the precedent of a prior three-judge panel, except in rare circumstances. But when we are sitting en banc, we are free to revisit any prior Ninth Circuit precedent we'd like. When the Supreme Court overturns its precedent, it must consult the stare decisis factors, and laid out in Dobbs, those factors are the nature of the legal error, the quality of the precedent's reasoning, its workability, its disruptive impact, and reliance interests. These are all factors that counsel judicial restraint. But when considering lower court precedent, I think the stare decisis factors all collapse into one factor, the first one, the nature of the legal error. And for an originalist, it's simple. If the circuit precedent fails to adhere to the original meaning of the Constitution, it should be overturned, period. The same prudential considerations that justify Supreme Court stare decisis simply do not exist at the circuit level. The Supreme Court governs the entire judiciary. It has to consider the implications of its decisions on the whole country. Concomitantly, it takes far fewer cases than circuits, courts. Some would argue too few, but that's a topic for another lecture. But overturning Supreme Court precedent presents far more complicated questions for stare decisis. But lower court judges are in a different league, the minor league. As Justice Barrett explained over 20 years ago, stare decisis should be at its weakest in lower courts. For example, because Congress is often aware of Supreme Court decisions interpreting federal laws, it can override its interpretations that it disagrees with. But in the case of the minor leagues of the Courts of Appeals, that same political consideration does not exist. Congress is unlikely aware of or doesn't care to correct lower courts' interpretation of the laws it disagrees with. So circuit courts are just playing in a different league, one that doesn't justify the same stare decisis factors from the Supreme Court. Circuit courts hear thousands of cases every year without a discretionary docket. Binding case law can be created with as few as 2 judges. Circuits only preside over small geographic regions of the country. And en banc proceedings often occur soon after the panel decision is issued, so reliance issues are substantially reduced. Finally, we're not the final word. The Supreme Court can always intervene if it disagrees with our decision to overturn our precedent. So while judicial restraint might counsel some hesitation before tossing circuit precedent, I think that bloodthirsty originalists among us should always seek to overrule non-originalist circuit precedent. Now let's focus on the world where lower court judges must grapple with precedent, when we have no discretion to overturn binding precedent, which is most often the case. The first question we should ask ourselves when confronting a presidential decision, say a Supreme Court decision, is what is actually the binding part of that decision? In other words, what is the holding and what is dicta? In our legal tradition, there's a difference between the opinion of the judge and the law. Chief Justice Marshall explained that general expressions in opinions which go beyond the case should not control the judgment of later courts. So we must discern what is the authoritative holding of a decision and what is simply non-binding dicta. But what method judges use to distinguish between the two isn't always clear. As I said, this distinction is important. The broader the holding of a case, the less freedom lower court judges have to depart from that precedent. On the other hand, the narrower the scope of binding precedent, the greater the opportunity for lower court judges to enact originalist decisions. So let's explore a few alternatives to see what we should do. The narrowest view of a holding is called the legally salient facts theory. Under this view, the holding of a decision is the legal rule defined by all the legally salient facts in the case. So any rule from the case is only binding on a case with the same material facts. The legally salient facts account results in very narrow rulings because in almost all cases there are numerous facts that are legally salient. So there are no broad rules to be discerned from a case. Taken to an extreme, this view could undermine the utility of any precedent. since a smart jurist could always find a legally salient factual difference in any case. The next approach is the ratio decidendi theory. Under this theory, judges are bound by the outcome and by whatever reasoning the court used to reach that outcome that is necessary to the case. Professors Randy Barnett and Larry Solon describe it as the holding is the legal norm that follows from the reasoning necessary to the outcome of the given case, given the legal salient facts before the court and the arguments made by the parties or raised by the courts. It's considered the most traditional view of holdings. As one judge said almost 100 years ago, the concrete decision is binding between the parties to it, but it is the abstract ratio decidendi which alone has a force of law as regards the world at large. First off, since the theme of this lecture is revisiting legal doctrines, I wonder if we can revisit the name of this theory. I could barely pronounce it, ratio decidendi. How about we just call it the necessary holdings, necessary reasonings theory? Second, it's been justified as encouraging judicial restraint because it basically says that an opinion decides the very case before it, and any rule from it is binding only as much as it is essential. It decides nothing further. The broadest approach is what scholars call legislative holdings. Under this theory, if a presidential opinion says that something is a holding, then it is a holding. For example, if the Supreme Court says, we hold that X, then X becomes binding law for the lower courts. This is true even if the holding reaches beyond the facts of the case. The rationale behind this is simple. If a court establishes precedent, then it gets to declare what is binding and what isn't. This promotes not just predictability and certainty, but it also ensures that lower courts are following what the Supreme Court understood it was establishing as the law. So where do I land among these theories? To be honest, I think there's problems with each of them. As I discussed, at its extreme, the legally salient theory may eviscerate all precedent. Simply, there's no question that lower court judges must obey precedent. The legally salient facts theory may allow judges to create razor-thin distinctions in a case to evade precedent. For example, a case could be on all fours, but if the issue was decided on a Tuesday, a Wiley judge might consider the precedent not binding because today is a Wednesday. That seems inappropriate. We can't take a cramped reading of a case to functionally overrule it. That said, I also have my issues with the ratio decidendi theory, aside from its name. It may present clear line drawing problems. How much of an opinion reasoning is necessary to its holding? What is necessary may be in the eye of the beholder. And if the reasoning didn't include originalist principles or our analysis, are we precluded from considering that in future cases? So we may face debates on what is necessary under this necessary reasoning theory. Some features of the legislative holdings theory are attractive. If the Supreme Court says explicitly that something is a holding, then respect for vertical stare decisis may mean that we should follow that declaration, especially if the declaration is narrow and specific. A fundamental rule of our judicial system is that we have to obey the Supreme Court even if we disagree. As the court said, unless we wish anarchy to prevail within the federal judicial system, a precedent of the Supreme Court must be followed by the lower federal courts, no matter how misguided the judges of those courts may think it to be. So it feels odd to say that we don't need to follow an explicit pronouncement of the court. But I understand that this broad view of the holding is the most problematic for getting the law right. First, and most fundamentally, it is a flawed view of what the law is. The law isn't what a judge pronounces it to be, at least in the constitutional world. Instead, our law is the text ratified by the people. So this view has tinges of legal realism, elevating the statement of judges to binding law. Second, as I see it, the legislative holdings theory requires us to predict what the Supreme Court is going to do. Because it takes statements of the court and applies it beyond the legally salient facts of the court's case, we're essentially predicting how the court would interpret the law in new contexts. So we are judging based on predictions, not on the original meaning of the Constitution, which is completely contrary to bloodthirsty originalism. In the end, I don't weigh definitively on which theory originalists should follow. I leave this complicated debate to the academics. Instead, I'll offer an example of how I've confronted this question. In 2020, the National Labor Relations Board issued a cease and desist order against a union agent for distributing flyers that said, quote, "Friends don't let friends cross," unquote, meaning that they shouldn't cross picket lines. To most folks, that statement seems pretty ordinary. But a federal law has been interpreted as prohibiting what's called secondary boycotts. A neutral union can encourage others to support another union's boycott. But does anyone seriously question that a ban on saying friends don't let friends cross is a type of speech protected by the original meaning of the First Amendment? Even under modern precedent, does anyone reasonably doubt whether it is a content-based or viewpoint-based restriction, which is generally a constitutional no-no? So the court should have easily reversed this decision in NLRB, right? Well, there's a problem. A 1951 Supreme Court case held that outlawing the encouragement of secondary boycotts is constitutional. In that case, the court said, the prohibition of inducement or encouragement of secondary pressure carries no unconstitutional abridgment of free speech. So that's a pretty bold legislative holding if we had one. Arguably, this 1951 case governed the 2020 case. After all, both cases dealt with whether the First Amendment protects the advocacy of secondary boycotts. A panel of judges of the Ninth Circuit thought so, but I disagreed. That's because I thought there was a good faith distinction between the two cases. In the 2020 case, the speech to support the boycott was distributed by text messages, phone calls, and flyers. Meanwhile, the 1951 case concerned the support of a boycott primarily through picketing. In my view, then, the 1951 case was not controlling. There's an ample basis for this view. In the 1950s, picketing was considered to be more than just speech. But in our modern case, we were dealing with pure speech, flyers, text messages, phone calls, not picketing. To me, these forms of communication were most like the political pamphleteering of the founding era, the heart of the free speech right. So I thought it was fair to say that the 1951 precedent should not be extended to the 2020 case. I thus supported a call to en banc the case. Unfortunately, that vote failed by a large margin. So hopefully that highlights how we should think about cases that are binding and when they are not. Now that we've broken down what is the proper approach to precedent, let's talk about a related question, the party presentation principle. Quick introduction. The party presentation principle is an extension of our common law adversarial system. Unlike other countries' inquisitorial system, our adversarial system is designed around the premise that the parties know what is best for them and are responsible for advancing the facts and arguments entitling them to relief. The party presentation principle requires judges to go not too far beyond what the parties have brought to them. But too broad an application of this principle poses problems for originalists. If no party presents arguments for the original meaning of the text, then it can be hard for a judge to consider it. Professor Barnett and Solom have come up with this handy chart to visualize how we may consider the party presentation principle. The broader a judge's view of the party presentation principle, the more the judge would be bound by the specific arguments made by the case. In contrast, the narrower the view, the freer the judge would be to consider other pieces of evidence or other reasoning behind a legal theory. So on the chart, if you have a broad view of the party presentation principle, that you're adhering to evidence, the smallest thing. If you take a narrow view, the claims view, then you have broader discretion to rule in a given case. When the party presentation principle used to be an innocuous principle. But since 2019, it has gained new teeth. In the case United States versus Senanang Smith, the Supreme Court used the party representation principle to strike down a Ninth Circuit decision as an abuse of discretion. Even though the court explained that Senanang Smith was exceptional, some lower court judges have overread its importance. Since the case came out, It's been cited over 800 times. And in many of those cases, it's been misused, in my view. When party representation warps a judge's ability to reach correct legal decisions, it becomes a problem. Given originalism's core commitment to getting the law right, the party presentation principle may sometimes function as a bar to considering original meaning. So, as the court said, we shouldn't consider it as an ironclad rule. After all, it's a tool of judicial discretion, not a constitutional command. So let's walk through the different ways judges may apply the party presentation principle. First, the party's claims view. Under this view, once a party raises a claim, the party has presented all the legal theories arising from the same claim, all the issues raised by the claim, and all the reasonings and all the evidence in support of that claim. This is the least constraining view of party presentation. Once a claim is identified, the judge is free to consider almost anything subsumed by that claim. Arguably, this is what the Ninth Circuit did in Sumner Smith. In that case, a criminal defendant argued that the federal alien harboring statute violated her First Amendment right. In particular, she contended that the law infringed on her free speech rights because the statute was unconstitutionally vague. Not liking that argument, the Ninth Circuit ordered supplemental briefing from select amici. And the Ninth Circuit asked whether the harboring statute violated the First Amendment rights not of the defendant, but of other people, meaning it was overbroad. In other words, the Ninth Circuit ruled based on a different First Amendment legal theory than what the defendant presented. It was this complete refashioning of the defendant's claim, combined with the appointment of an amici targeted for a specific purpose, that caught the Supreme Court's ire. Second, the party's legal theories view. Under this view, once a party raises a legal theory, judges are limited by that theory, but may consider anything else subsumed by that theory. So if a party raises only a particular statutory theory, they have not presented any theories based on any other statute, any constitutional provision, or any common law theory. Under this approach, judges are free to engage in originalism within the legal theory brought by the parties. The rationale is simple. If our job is to get the law right, thus we cannot let the parties lead us astray with incomplete or bad arguments. Arguably, some might say I follow this view of party presentation in a recent case called Coalition of the Homeless versus San Francisco. As a background, the Ninth Circuit has an unusual precedent that says that a city criminalizing vagrancy laws violates the Eighth Amendment's cruel and unusual punishments clause unless it provides shelter to every homeless person in the city. A district court then expanded that precedent to San Francisco, even though its vagrancy laws left some areas for the homeless to sleep in public. San Francisco gave its legal theory in the case, that enforcing restrictions on occupying public property is constitutional so long as the individual has somewhere to sleep. Given that opening of a legal challenge, I took the opportunity to undertake a full-blown originalist analysis of the Eighth Amendment's cruel and unusual punishments clause, going all the way back to the English Declaration of Rights of 1689 and the trial of Titus Oates, which is generally considered the predecessor of the cruel and unusual punishments clause. Given this history, I concluded that our precedent conflicted with the original meaning of the clause, and in a dissent, I held that our precedent should not be extended to strike down San Francisco's laws. So next we have the party's reasonings view. Under this view, the party presentation principle requires that parties raise particular reasons for their positions on issues, legal theories, and claims. So if a party proffers an argument about the original meaning of a constitutional provision, that argument has been presented, but alternative arguments have not. In the homelessness case, once a party makes an argument about the original public meaning of the Eighth Amendment, judges would be free to consider the Declaration of Rights of 1869, even if no party presented that specific piece of historical evidence. But judges can consider other reasons, even related reasons, such as arguing that the Eighth Amendment doesn't apply to civil ordinances, which some have held. Finally, the most stringent view of party presentation is the party's evidence-only rule. Those that believe in this may not consider anything other than what the party presented, from arguments and reasons all the way down to specific historical evidence. So you couldn't consider the Declaration of Rights of 1869 unless the party specifically presented it to the judge. Under this view, it seems that the parties control everything about the case, even the meaning of governing law. One, I think, extreme example comes from a DC Circuit case. In that case, a judge wanted to decide a case relying on a statute that might have been repealed. The judge explained, because neither party had brought up whether the law had been repealed to the district court, it was inappropriate for the circuit to consider it. This view posits that a judge may accept the party's stipulations to the law so long as the issue is not jurisdictional. In my view, it is an abdication of the judicial duty to allow parties to stipulate to incorrect law. Even if they agreed that a certain view of the law is binding on them, parties have no obligation to ensure that the interpretation of public law is correct, but judges do. In one Americans with Disabilities Act case I worked on, the parties agreed that a Department of Justice guidance document was the governing law, not the actual text of the ADA regulation. Mind you, this came right after the Supreme Court in Kaiser versus Wilkie told us that courts should be careful in holding agency interpretations of law as binding. The majority reflexively accepted the party's legal stipulation because neither side questioned the validity of the DOJ guidance document. However, I disagreed. Even though judges generally rely on the arguments the parties advance, we should never abdicate our independent role in interpreting the law. So if the parties don't offer the correct reading of the law, we are not bound to blindly follow their lead. Instead, as judges, our duty is to get the law right. As Justice Thurgood Marshall once said, when an issue or claim is properly before the court is not limited to the particular legal theories advanced by the parties, but rather retains the independent power to identify and apply the proper construction of governing law. After all, judges are not like lemmings, following the parties off the jurisprudential cliff. Likewise, judges shouldn't close ourselves off exclusively to the history presented by parties. We should be looking at all available history on our quest for the original public meaning. Just like we wouldn't ignore a dispositive case if the parties fail to brief it, we shouldn't close ourselves off from any historical evidence that would help us reach the right conclusion. If a judge feels that historical research is incomplete, the judge may do several things. One is do in-chambers originalism, look to the original sources themselves and try to discern meaning. Or two, rely on publicly available originalist scholarship. This is often what I do. I look at the scholarship and look at the sources they look and try to interpret it. Three, they could ask for supplemental originalist briefing. Or four, they could invite amici to brief on originalist grounds. What would be improper is to refuse our duty to get the law right. So now that we've talked about some of these principles of judicial restraint and how they relate to originalism, let's put it all together. Here's my bloodthirsty originalist roadmap. I believe our fidelity to precedent cannot be blind. Our duty is to apply the Constitution, not to extend precedent. So I follow Justice Scalia's caution in Noel Canning that we always have a duty to interpret the Constitution in light of its text, structure, and original understanding. This doesn't mean that lower court judges can refuse to follow precedent even if the original meaning casts it into doubt. But where precedent is seriously questioned as original matter, as Justice Thomas said, courts should tread carefully before extending it. Thus, we should read precedent in light of and in the direction of the constitutional text and constitutional history. So functionally, what does that look like? To me, I think it means we do a two-part analysis in each case. First, we start with first principles. If the party raises a claim under a particular constitutional legal theory, we analyze that argument as purely original matter. We look to what the text, history, and tradition tell us. Often that means consulting historical sources or reviewing originalist scholarship, as I said. This may mean that we look beyond what the parties presented in the case. As long as the parties presented the legal theory, we are free to consider all evidence necessary to determine the original meaning of the text. We then consider what the Constitution as an original matter would dictate in that specific case. So that's the first step. For our second step, we consult modern precedent. We analyze the question of the principles of stare decisis and faithfully figuring out what the holding of a case requires. In doing so, lower court judges don't have a license to adopt a cramped reading of a precedent in order to functionally overrule it, nor are we permitted to create razor-thin distinctions to evade it. But neither are we required to take an overly broad view of what a holding of a binding precedent is, or to predict how the Supreme Court would rule on that case based off of legislative holdings. Once we fairly separate dicta from holding, we are then free to examine how to apply the precedent in that particular case. If there's a conflict between the two, where the original meaning and modern precedent are at odds, and if the modern precedent is not directly controlling, that means we should not be extending that precedent. Instead, the originalist judge should bend the precedent towards the original public meaning of the Constitution. Of course, if you're sitting on banc and you have ability to overrule prior precedent, you should do so if there's a conflict between the original public meaning and precedent. But if there's no conflict between the two, that the original public meaning and precedent align, then I see no problem with it extending it in that particular case. As Justice Kavanaugh recently said, when determining how broadly or narrowly to read a precedent, when determining whether to extend, limit, or narrow a precedent, a court will often consider how the precedent squares with the Constitution's text and history. The text, as well as pre-ratification and post-ratification history, may appropriately function as gravitational pull on the court's interpretation of the precedent. It is this gravitational pull that the bloodthirsty originalist judge should focus on. We can respect precedent even while bending it in the direction of the Constitution's original meaning. So this is a call for lower court judges to consider originalism every day. I was once talking with another judge, an extremely prominent one in the conservative legal movement and an avowed originalist, and actually a former Canary lecturer. And he told me that in his entire judicial career, he's only looked at the original meaning a handful of times, 4 or 5 times. Frankly, that rattled me. It wasn't long ago that Justice Scalia stood alone, insisting that the Constitution means what it says. And now the Supreme Court and the lower courts are dominated by originalism. It's truly a golden age for those who believe in originalist principles. And yet, even after all this success, we face those that say, yes, I'm an originalist, but there's a time and place for originalism. Most issues have already been resolved, so I'm only going to analyze original meaning in the rare case when I'm presented with a complete blank slate. I'm here to say that lower court judges can do originalism, not once or twice in a career, but once or twice in a day, be it in a majority opinion, a concurrence, or a dissent. I think people sometimes misunderstand what it means to be a bloodthirsty originalist. It's not subcategory of originalism where we go after a meaning that is extra original. I think the reason why Justice Thomas embraced the label is because being a bloodthirsty originalist simply means you're always an originalist. In conclusion, even in the pursuit of bloodthirsty originalism, we still have a set of duties that we cannot disobey. This includes a duty to follow binding Supreme Court precedent and a duty to follow the party's theory of the case. But respecting those limits, we must recognize our highest duty is to the Constitution, the people's law. And that means that we should push the law towards original public meaning every day. Thank you very much for having me, and I'm happy to answer any questions. Go ahead. Am I paid to answer questions?
Yeah, do we have a microphone?
Thank you, Judge. I want to go back to one of your early slides with Chief Justice Warren.
Go ahead.
60, 70 years ago, as you said, the Supreme Court tended to make decisions that push the boundaries in a lot of people's view. And so the response was conservatives suggesting that we should have a more restrained judiciary.
Right.
Today, we have a more conservative judiciary, and that judiciary is viewed by some folks as pushing in the other direction, to which people on the left have been suggesting, well, we should have a more restrained judiciary. So I want to step outside of the law school or the bar situation, the context, and ask, if you are a non-lawyer looking at this history, what can we say to the non-lawyers who ask, doesn't this just mean that the law is all about politics?
I mean, the answer is very simple. The law is what the people ratified. And you can't rely on judges to change that, even if you don't like it. So the simple answer I would say is, this is your law. If you dislike it, change it. You can't look to judges, individual judges, to change it for you. That's the most anti-democratic way to do things. I mean, frankly, why would you want me, to decide these life and death questions based off of my personal political preferences or things of that nature? Instead, what we should be saying is judges need to follow the law in all times, in all cases. And if people don't like it, it's up to them to change it.
I have many questions, but let's start with this one. How does a bloodthirsty originalist deal with amendments? And focus on the 14th, if you would.
Sure. The constitutional, that's exactly what I was talking about. If the people want to change a law, then they need to change it through the amendment process. And that's exactly what happened in 1868. And after the Civil War, the country came together and said, we are going to enact this anti-discrimination principle through the 14th Amendment. So therefore, we need to apply that principle throughout in every case. Does that answer your question?
Yeah, I was really trying to get to the methodology you would use, because one of the questions is, well, what is the original meaning? The Constitution was a compromise document.
Sure.
And those who did the drafting were attempting to capture a phraseology that a majority of the delegates would accept. Mm-hmm. And the people who ratified it was the several legislatures of the states at that time.
There was state conventions where some people voted on it, and then some state legislatures. Yes. But yes, it was the Constitutional Congress that proposed it first, though.
But how do you even know what the right originalist meaning is? Time travel is not possible. Yeah. Not all views are documented.
Yeah.
And then when you layer on amendments, then one can no longer ask the question, what was the commonly held view of this meaning of this word in 1791?
Right, so there's a lot to unpack on there, but I think those are very good questions. So my first answer is, number one, you're right, it is sometimes difficult to understand the original meaning of the constitutional text. Sometimes the history, the evidence of the constitutional text is so vast that there's no way we can go through it all. Sometimes the evidence is just lacking, right? It's really hard to find any evidence of what the meaning is. Like, for example, I think the freedom of speech is a tough term to figure out as an original meaning. But that doesn't mean that we give up on this hope. That means that we should be careful and discerning. And so what I think this counsels is that when you are looking to employ the original meaning, you better be sure, right? We shouldn't be doing this willy-nilly. It's not a 51-49% chance, right? If you think it's a 59% right answer, That's, in my view, that's not sufficient to be overturning the democratic process that I've talked about. We need to be very sure of what the meaning of the constitutional provision means. Second, it requires judgment. Like, there's just no way around it. When I said that originalism is a constraining principle, it is. But there's no method of judicial interpretation that takes away discretion. There's always going to be discretion and judgment needed in judging. That's why I think my job is safe with the advance of AI, which is great for me. So that requires that kind of discernment. And so I had one other point, then I lost it. But I'll think about it kind of.
I just want to follow up on that kind of concept of the historical nature that you referenced, that judges need to look at the history of things. And I believe you actually went back to a case from the 1600s in England as one of the things you were drawing on as a historical example. But where do you draw a line? If you go back to Blackstone, if you go back to Magna Carta, there are treatise writers about Magna Carta who say that Magna Carta was a living document that was supposed to be viewed in terms of the society of the time. As times change, the interpretation of Magna Carta changes. You suggest that that would not be true for our Constitution. So how do you balance your historical analysis under those kinds of circumstances?
Yeah, it's simple, really. We're looking at the historical meaning at the time it was ratified. So whatever the meaning of the Magna Carta meant in, I think 1400s, when I think it was 14th century, it doesn't matter. What matters is how the people understood it at the time of the ratification. So, you're not interpreting the Magna Carta as it applies today. The reason why you look to the Magna Carta is because it has a predecessor of the Due Process Clause. It has something, I forget the exact phrasing, but that's what kind of was the predecessor, the early ancestor to our modern Due Process Clause, and that's why it's relevant.
You had also a slide with Justice Gorsuch's little slap on the hand to a lower court judge about following Supreme Court precedent. As a lower court judge, how are you to make out what the court decision actually means or the precedential value of it when it's in the shadow docket or emergency docket concept rather than in a full decision with any kinds of analysis provided?
Yeah, I mean, that's a difficult question, right? I understand that. I understand both points of views. In the context of this particular case, it dealt with the cutting off of funding by the federal government. The reason why I think what Justice Gorsuch said was somewhat justified, there was at least 2 to 3 other cases that had the same fact pattern, right? Where there was a party that complained that funding, the federal government cut off funding, caused them a harm. There's a law called the Tucker Act that says that any type of claim that's based off of funding contracts has to be brought in the Court of Federal Claims. And to me, you look at those 2 cases and you could read the circuit court opinions, the lower court opinions, and you could see that those cases were all fours with the case that prompted this argument. So I get the concern and that that these interim orders are not the most fulsome arguments, fulsome opinions, but we could look to how they've resolved other cases that are directly on all fours. And I think in that particular instance, there were 2 or 3 cases that showed us what we should have been doing.
Hi, 2 quick questions, but first, welcome to Cleveland.
Thank you.
Where if you're not a Guardians fan, you should leave. Question 1. What specific words in the U.S. Constitution are the source of authority for strict originalism? Question number 2. Why is it so damn difficult to get equal protection in the United States of America, even from strict originalists who ought to be applying equal protection equally to all people who appear before them?
So I'm not sure what you're referring to on the equal protection issue. If that's a particular case, I probably can't comment.
No, it's not a particular case. It's a concept. It's a concept that as we watch strict originalists retake history, judicial history, which I actually understand. I don't agree with this, but I do understand that if your view of the world is it ought to be X, and you think that for 50 or 60 years it's been the opposite of X, then you have to throw out stare precedent, right? You have to throw out precedent, adhering to precedent,
Right.
to get back to what you think is right.
Correct.
So this conflict of concepts, how do I do what's right, but how do I accept precedent, gets thrown to the wind. You can't accept precedent. You have to go back to something you think is right.
Right.
But in the source of all that, in the battle of all that, countless people come before the courts seeking something simple called equal protection, whether it's over gender issues, whether it's over race issues, whether it's over financial issues. People come to the court seeking equal protection all the time. It is the most elusive, evasive thing in the history of this country for people to get equal protection. And I would suggest to you that the history of jurisprudence in America shows that it's super hard to get equal protection from you and others who adhere to your strict originalist views. So that was the second question. Okay. The first question is, what's the actual language in the U.S. Constitution that you and your followers see as the source of authority for your approach?
Sure. So I'll answer that question first. I mean, Article 3 says the judicial power, right? The judicial power means something. It means that judges are only applying what the law is, not what they want it to be, and they're not allowed to change it based off of changing norms or values. It is, as Hamilton said it, it's neither force nor will, merely judgment. So it's the judicial power that requires an originalist undertaking. And I think I kind of want to do this talk at some point. If you look at all the founding fathers, many of them, John Marshall was an originalist. They would talk about how the words of the Constitution needs to be interpreted at the time of its ratification. This is not a new concept. It's gaining salience now, I think, because of the judges being appointed recently. But it's been around for 250 years. Akhil Amar gave a talk where he said Abraham Lincoln was an originalist. John Marshall definitely was an originalist. So this is not new. On the question,
but all that language is not in the U.S. Constitution.
Well, it's interpreting the meaning of the judicial power.
But all that language is not in the Constitution. So a strict originalist couldn't go back to the Constitution and say, there's the word that gives the source of authority for my belief.
I disagree, because what originalists say is you look at what it means, what the judicial power meant at the time it was enacted in 1789.
But that is an act of interpretation. That's not an act of strict originalism.
No. I think maybe I'm not explaining it properly. Originalism doesn't mean that we're not allowed to interpret. In fact, that's often what we're doing. The Constitution is a Constitution because it gives out broad principles. It's not meant to answer every question for all ages. It gives high-level principles that we are supposed to discern and give meaning to. So, for example, when I'm talking about what the judicial power means, we are to look at what it meant at the time, which looks, and I would argue that is a term of art, that has a meaning in the common law of the time, which means that judges are supposed to decide only the meaning of the law. They're not allowed to change it or interpret it in a way that's contrary to its meaning.
Is there an answer on the equal protection question?
I mean, that's just, I hate to answer that question in a vacuum. I need to, so I'm going to duck that question. I apologize.
That's a fair answer.
Hi, I think it's safe to say that you have a high opinion of the Constitution. So,
yes.
And so much as that it should, rule the judiciary. My question kind of, I want to look outside the judiciary to the other three branches. Do you believe that the Constitution is being sufficiently followed in every branch to allow this sort of imbalance in power that may result if only the judiciary is strictly using the Constitution in its proper form and maybe the other branches are not? Do you think it has implications on the balance of powers that the founding fathers wanted to have in our government?
Yeah, I think it's definitely correct that the founding fathers thought that each branch would independently interpret the Constitution and follow the Constitution. and that each branch will have an independent duty, and frankly, they do have that independent duty. I think you might be correct as a practical matter that it seems like today that the other branches are just trying to get as much power as possible out of the Constitution, and that's why it's left to the judiciary to kind of limit it. And I'm not sure that that's the original way the founders would have envisioned it, but it is the system we have today.
So I guess I would like a clear answer on, do you believe that the other branches are following the Constitution?
I mean, that's just a broad concept. I'm not sure I can say yes or no. I do think there are instances where the other branches, the political branches, have tried to gain more power than granted to the Constitution.
So if it may not be working, do you find that there may be a call to re-examine if we should be using it as strictly as you say that we should be using it?
Well, I'm not sure I agree with you that it's not working. I think the system is working very well. That's the whole concept of judicial review. Since Marbury versus Madison, it's been decided that the courts would be the final interpreter and arbiter of what the law is. And so that's a system we've developed over the last 200 plus years. And so I disagree whether or not it's not working. I just take it that your point that as a factual matter that there are instances that the political branches may be trying to exceed their authority.
So we have time for just one more question. Betsy, you're going to close us out, and then we'll have a reception after you talk with Jared.
Happily, thank you. So in this primer for the bloodthirsty originalist that you present, how do you suggest that the bloodthirsty originalist should approach situations that could not have been anticipated by those developing the principles of the time, right? That there are broad principles
Yes.
that presumed a certain state of the world technologically, for example, and in terms of population density and things like that. Do those matter? Do those changes, technological changes, population density changes, things like that, matter, or should they matter to the bloodthirsty originalist, given that they could not have been anticipated at the time of the framing?
Sure. The answer is yes, they do matter. But what's the brilliance of the Constitution is that it gave us these broad principles that we can apply to these modern situations. Of course, it's true. Thomas Jefferson did not know how the First Amendment would interact on the internet, for example. Of course, that's true. Or James Madison would not have known that. But what the First Amendment does give us is principles that are applicable in multiple situations, including the internet. And so that's what the bloodthirsty originalist is supposed to do. Look at what the principle is of the First Amendment and apply it to this new situation. This is not different than any other form of judicial interpretation, right? Every judge has to analogize the case that's before him or her to previous either authorities or previous cases, if you believe in precedent, or other concepts, right? All I'm saying is that what an originalist should do is analogizing it to the original meaning of the Constitution. This is not a foreign concept for judges. This is something we do every day.
All right, I'm sorry to cut through the conversation. We do, of course, have a reception immediately after, so we can continue the conversation there. Again, thank you, Judge Bumatay, for being here.
My pleasure. Thank you.
You don't want to be on camera. This is the place to be.